joined us here today for this webinar. Another one among a stream of webinars that we are actually having throughout this lockdown period. But this one has a bit of a twist, because apart from simply talking about the carrying out a short recap about insolvency law and practice and the policies in India, we have with us our speakers who are also going to provide a little bit of advice on how exactly, what exactly does it mean to be an insolvency lawyer in India, and how to make a restructuring insolvency a career option as such. This entire webinar idea has actually been it's actually been carried out hosted by SkillxPro in association with company and NUJS, of course. Was about Ravitej and company. There is no need for introduction as such. We all know of their reputation. And SkillxPro is essentially an online education platform for skilling, upskilling, and getting placements for law students and young years. They essentially do this through different host of courses, which are curated and developed by industry experts and law firms to basically impart on-demand skills to help the students bridge the gap between college education and profession. Now, these courses, as Utkarsh, the founder of SkillxPro, tells me, are based on overall practice areas that ensure that the students get the appropriate skill to specialize and work in the relative practice areas and all. And the students should also be mentored to prepare them for recruitment processes, interviews, etc. Now, after that, they directly refer internships and placements to top-tier law firms and corporates and so on and so forth. About the speakers, now we have with us, of course, Ravitej Chilimuri. Ravitej, for those who do not know, also happens to be an alumnus of NUJS. He's currently a principal associate at Ravitej and Company and with the litigation team in the Mumbai office. He has, over the past years, represented some major matters in insolvency law, including, if I'm not mistaken, representing JM FRAC in the Leela Hotel structuring related dispute, representing the resolution professionals in the Videocon Oil Ventures Limited at CIRP matter, representing several other financial and operational creditors and resolution applicants before the NCLT. And if I'm not wrong, he's also currently representing others in the ILFS restructuring at present. And I also have the privilege of course, having been a senior to Ravitej back from my NUJS as a student. And a very warm welcome back to Ravitej. Looking forward to hearing from you today. I also have with us Zacarias Joseph, who is a senior associate at Ravitej and Company, and he also works with the litigation team of Ravitej's Mumbai office. Mr. Joseph has advised on the insolvency of several prominent deals like the Dighi Port Limited, the Garden Silk Mills Limited, and so on and so forth. He's also involved in the very first few personal guarantor matters under Part 3 of the IBC. So we are lucky to have two people who are not only skilled in about their respective subject areas, but they would also exactly know firsthand what it means to be an insolvency lawyer in India in the light of IBC. Before I actually pass over the mic to Ravitej and Mr. Joseph, few basic instructions for the webinar. I'm sure all of you are already aware of most of it, but I'll just reiterate it nonetheless. First of all, everybody, please place your mics on mute. Otherwise, we have so many participants that almost nobody would get to hear anything because of background noises. Feel free to ask questions, but your questions shall be taken up. You can share all your questions in the chat section, and your questions shall be taken up at the end of the session, 2 sessions that we will be having. And Utkarsh has promised me that if due to paucity of time, we are unable to take all questions right now, we will be reverting to them separately. We will be having the entire webinar is divided into essentially 3 sessions. In the first session, and Ravitej and Mr. Joseph will be dealing with several issues regarding the IBC, the what and why of the IBC, how exactly does the process commence, and how important IBC is for the lawyers, etc., etc. And in session 2, there will be it will be more in the nature of a Q&A session, and we will be responding to questions which will help us understand the career path in restructuring and insolvency practice area in India at present. And of course, that an extension of the Q&A session, they will be responding to the questions that any participant might be posing to them in course of the session itself. So without any further ado, I'll ask Ravitej to take over and share with us his insights. Thank you.
Thanks, Shavik. Firstly, we've been wanting to do something with NUJS for a really long time, and it finally took 8-9 years to collaborate with them, which is great. It's never too late. Thanks, Shavik, for the introduction, and thanks, Utkarsh, for this opportunity and for also putting this together. So before we start, to quickly just lay down the contours of the session. So we're going to the first part of it, we'll divide into two bits. I'll discuss the what, why, and how of the Insolvency Code, why it was introduced, what it does, who does it benefit, and how does it work. Then in part 2, Zach is going to just discuss the career options that there are today for insolvency lawyers. We're happy to address any questions that you guys may have at the end, or even later. So to quickly just dive in, the first question, the why. Why did we need a new regime? Why did we need a new code? Why did we need a new law? We've heard enough of how on the ease of doing business index, India rated fairly low, much lower than what you would expect a country of this economic strength to rate. A lot of foreign investors were very wary of coming to India because they felt that you had too many bottlenecks, be it the bureaucratic bottlenecks, the legal regime took a lot of time, litigation was far-stretched, too many layers, nothing was time-bound. It was always a very promoter-driven process also. So in a lot of cases, we saw the investors didn't derive the ROI that they expected of it. There are 3 or 4 crucial restructuring mechanisms that did exist prior to the code coming in. Some still exist, some are not, have been repealed. The first is SARFAESI Act. A lot of criticism because it sort of was more towards enforcement and not for a revival. So the criticism is that it's not an inclusive regime as such. Then you had the DRT process through the Recovery of Debts Due to Banks and Financial Institutions Act. The biggest fallout of it was you had a tribunal, the DRT, which was overburdened with cases, with litigation which they could not handle, which led to things moving at a very, very slow-paced speed, and also therefore did not lead to much recovery really. And the other thing is it was limited to a certain set of creditors, banks and financial institutions only to approach, and not all sorts of, all classes of creditors per se. Then you had the SICA, which did get repealed now, which was again sort of prescribed to revive a sick company. But the problem was it was still under the same management, which itself made it ineffective. There was a lot of delay. Promoters were using the SICA, were misusing the SICA to sort of exploit the moratorium. And therefore the regime caused, the legal regime under the SICA caused more problems than solved it. Then you had the CDR, the corporate debt restructuring, the strategic debt restructuring under the RBI. It did sort of come in to help in some ways, but it came in very late. And 2, it was voluntary. It wasn't like the IBC, a creditor-driven process. So with all of this, they felt they needed one sort of collective mechanism which reorganized and resolved companies which were in stress, and they did it in a time-bound manner, which is the objective of the Insolvency Code. Some of the key things, and as lawyers, we need to keep in mind, because a lot of times when a client comes to you with a debt, your first thought and their first thought is, how do I recover the debt? The Insolvency and Bankruptcy Code is not a money recovery mechanism. It may lead to money recovery. It is a very good pressure tactic to push someone to settle, especially for a debt which is not large enough for them to run the risk of getting into CIRP. But by and large, it's still a recovery mechanism. It's a restructuring mechanism and not a recovery mechanism. Why? We'll come to that later. Um, Unlike SICA, banks stand to benefit from this process because the SICA sort of the promoters were misusing to get all litigation stalled, etc., and all of that. But with the insolvency process, it's a creditor-driven process with the banks sitting on the committee of creditors, which sort of orchestrates the whole thing, which is why at the end, banks find maximum realization from this, and which in turn leads to more credit in the Indian market, which in turn leads to a more thriving economy. Um, in the earlier regime, you had promoters which participated in the bidding process, reacquired the same assets at a deep haircut, which sort of led to a lot of frustration among the lenders. IBC, on the other hand, is now seen a power shift from those of the shareholders and the debtors to that of the creditors. The code has sort of tried to ensure that the same management which sort of got the company to the position that it's in today don't get a second hit at it, which is also why an amendment like the 29A came in, because the legislators felt that the same people who led a company to a debt-ridden stage are not the same people who now acquire the company just at lesser with a clean slate and take it forward. So this sort of increases the promoters to be more vigilant as far as running their companies are concerned, as far as not ensuring that their companies are not stressed or their debts are by and large paid to the extent that they can, and no one can misuse any legal regime to sort of get away with things, so as to speak. And that in turn has led to increased trust of the investors. We used to have a lot of clients who were very nervous putting money into Indian assets or Indian companies because they felt that the recoveries or their returns took a lot of time. There was uncertainty of litigation. There is no time-bound process. To that extent, the insolvency code sort of picks up best practices from the UK, from the US, and has come up with something which in intent has its heart at the right place. It looks at getting as maximization of value, doesn't allow promoters to misuse the company, and therefore is something which a lot of people felt was the need of the hour. Now, how does it benefit and who benefits from it? Primarily to sort of, to, if I can say, to dumb it down, what it essentially does is it allows for creditors such as, financial creditors, operational creditors, companies, guarantors, corporate debtors, individuals to sort of invoke the provisions of the code. When do you invoke it? When there is a debt and there is a default of that debt. The most common ones that we see as lawyers today are financial debts and operational debts. Financial debts are your time value debts, which you see, which is basically money lent to banks, NBFCs, etc. And the other one that we see are operational creditors. Operational creditors are those people who've lent you money against provision of goods and services. Could be, consultancies, could be giving goods, could be supplying raw material, etc., etc. These are the two most common type of creditors that we see. What's the forum for disputes or for issues arising out of the insolvency code is the National Company Law Tribunal. An appeal from that goes to the National Company Law Appellate Tribunal, and then in an SLP to the Supreme Court if and when. It's also important here that we've seen cases where the writ jurisdiction of courts have also been invoked. In some cases, courts have sent them back saying this is not the appropriate forum. In some cases, they have entertained it, but more so in a limited fashion to go and ask the NCLT to do things a certain way. So by and large, under this regime, you have a specialized forum hearing disputes, which by itself has sort of made things faster. You're not stuck in a tribunal which is overburdened in most cases, but you have a tribunal where there are benches which are by and large hearing matters under the code. Having said that, the code does prescribe a certain time period within which things have to happen. We've seen that not strictly followed in practice because you have courts which, litigation is never time bound. Like you can never tell a court, I want you to hear and pass an order in 14 days time or admit it in 14 days time. It's in some ways unrealistic. So the court does give you an upper limit, extendable as well. But then people were still using the time spent in litigation to deduct from that time period, where the Supreme Court in SR Steels comes in and says, no, you can't do that. Even if you're litigating, the broader outer time limit is 330 days. A lot of people felt that when the Insolvency Court came in with the amendment of 330 days, it was draconian, it was not fair, because what if a company on the 325th day is close to resolving but needs, say, 15 days. So SRC qualifies it to say while you try and follow 330 days, that amount of flexibility remains. So the biggest thing this does is it puts in a time-bound system by which you need to get things moving. You cannot misuse the process. I keep coming back to misuse because that's been one of the biggest grievances of investors and lenders in the past. And there, the role of lawyers comes in even more because you are one of the biggest stakeholders in the practice. And it's a lot of the responsibility of getting things done on time rests on you. How and when, Zach will discuss it in some time. But I think we can't always pin it on courts for delay. Lawyers play an equally important role to ensure that things happen quickly and on time. What's the process like to quickly, to simplify what the process is for a financial creditor or an operational creditor to approach NCLT to seek corporate insolvency process against a company? Let's say I'm an operational creditor or a financial creditor to company ABC. I've lent money, there's a debt, there's a default. I file an application under section 7 or 9 of the Insolvency Code before the NCLT. If I can prove that there's a debt and there's a default and if I'm an OC, there's no dispute, the NCLT admits my application and interim resolution professional gets appointed. What does that mean? What that means is the board of directors of the company gets replaced with the IRP basically takes over the functions of the board of the company. This itself is the first departure from the SICA regime where the directors sort of still control the process. Here they are out, somebody else steps in. The IRP then calls for claims from various creditors. Once he gets the claims, he picks out the financial creditors and forms the committee of creditors. The committee of creditors are now the decision-making body of this company and not anyone else. Who forms the COC? It's the financial creditors, as I said. Here, there's been debate on whether the operational creditors should be getting a seat on the COC or not. There's been enough debate. While people talk about there should be equality of treatment to some extent, courts have by and large said that the financial creditors are more skin in the game and therefore they should be the one driving decisions. The COC then confirms the IRP and or appoints a fresh resolution professional. They call for expression of interest to take over the company. Once plans gets submitted, the highest bidder, so as to say, or the best bidder, so as to say, sort of gets to pick the company and then takes it as a going concern. This whole process, if you notice, is sort of points towards a system where points towards a system where the people now in control of the company are really the ones who have the maximum interest today, because it's the lenders who want to sell the company or give off the company for the highest possible price or at the most investment efficient price, because at the end that's where they gain. And that's really what the bottom line is. You maximize the value, you maximize the asset value, you maximize the returns, and you give the company to somebody in a way that these lenders who otherwise had no hope for recovery get the money back. One of the most important aspects of this is section 29A, which says that who can submit a plan. It keeps the people connected with the company and their family and their related parties out of the scope. Why? Because you can't have people who sort of ran the company to ground again go assume control of the company, because then you're running the same cycle. Because if at one go you could not have sort of taken care of the company the way you should have, there's no good reason why a committee of creditors is going to have enough faith and confidence in your abilities to now take the company forward. There have been about now how really has the process benefited people? Um, the earlier process as regimes, there was a recovery rate of about 25% of the net debt that went into litigation. Today, you have about 43%, which is, in itself is a huge rise. Since the IBC process came in about 4 years back, we've seen about close to 3.5 crore of debt being disposed of even before admission, which is what brings me to your role as an insolvency lawyer is how do you strategize? How do you put pressure? How do you sort of take it to the debtor in a way that you use this mechanism to recover your debt, and companies cannot any longer come up with excuses to not repay debts or delay the whole time process or get into expensive long litigation to avoid having to repay money. Here you have a process which the moment admitted gets the promoters and directors out of the picture and gets the others in. Now what that does is it sort of gives enough drive to the creditors or to the debtors to ensure that you don't that you don't hold on to debt which you'd otherwise are in a position to repay or is legally repayable as well. Which is probably why there's the gross NPA in the banking sector has come down by at least 2% in the last financial year. Actually, no, my data is from March year and 19. The NPA was about 10% as compared to say 12% the year before that. So what I'm essentially trying to say is that you have a process which has multiple stakeholders. You have uh, a time-bound mechanism. You have an NCLT which is continuously supervising the process, an NCLT which allows for a provision which lets you knock the doors of the NCLT if you feel anything about the CIRP is not going the way it does. So there's a lot of skin in the game. There's a lot of trust that's bestowed on all stakeholders. More importantly, lawyers, because we see our roles changing every day. We are representing, resolution applicants. We're representing creditors. We're representing creditors who are sitting on the COC. We're representing the COC as a whole, and we're representing um, dissenting applicants, and obviously the RP, as I've already mentioned. So we are wearing different hats on different days, and our roles for each changes. But the bottom line is, and as a lawyer, what I believe and what I've seen work is you need to sort of be faithful to the system to the extent that you need to understand that this law obviously will grow, there will be glitches, and instead of trying to find loopholes to delay and extend things, we need to find a way to sort of move ahead, because at the end of the day, it's all part of the same thing, right? If a company gets resolved, there's more credit in the market, there's more money in the market, there's more investments, the general market health improves, and that gives you more work net. How we can benefit as lawyers, what we do as insolvency lawyers, what is it that we do on a daily basis, how we wear different hats, what our roles, etc. Zach's going to take it from here. So Zach, do you want to take this now?
Sure thing, man. Thanks, Ravitej, for that presentation. Utkarsh, can I request if you could put the slide up, please?
Sure.
Right. So while Utkarsh puts up the slides, I hope you all have gotten a decent idea of what exactly the IBC is about. Like Ravitej mentioned, it's meant to be a sort of adverse, drastic measure that parties can take when they're not paid their money. There are financial creditors who are really banks, and there are operational creditors who are people who who have provided goods and services and haven't been paid for that. Like Ravitej mentioned, there is the NCLT, which is a specialized tribunal which hears all these matters. I'll touch upon sort of what the opportunities are, and the idea of this part of the presentation really is to give you, plain and simple, what are the career options. The law has been around for about 4 years now. In fact, a little less than 4 years. December 2016 is when it came into force. There have been, lots of developments that the Supreme Court has ruled on a number of issues. So when you go back after this presentation and you read about the insolvency law, you will see, there are two very important judgments of the Supreme Court in the Innoventor versus ICICI Bank case and the Mobilox versus Kirusa innovation case, each on Section 7 and Section 9. But look, we don't want to trouble you with the technicalities. You all are still in college. You all will still understand all this. The idea is to give you some practical realities, right? So, as I see it, and I think Ravitej would also agree with me on this, there is a broad scope for lawyers. As law graduates, there's a broad scope of sort of options that you have once you have some sort of mastery over the insolvency law. Broadly speaking, there is litigation as a career choice, and then there are transactional lawyers. So what Ravitej and I do is sort of in litigation, we appear before the NCLT, we brief senior counsel in the NCLT for different stakeholders in the process. But what I want to tell you here is that there are two broad sort of categories of litigation. One is the pre-admission phase. So what is pre-admission, you may ask? Pre-admission is what Ravitej touched upon. Section 7, 9, and 10. That is when you actually go to court and make the application for the commencement of the insolvency process. That is prior to the admission of the application. So look, we can tell you with some degree of confidence that because the sort of financial thresholds are very low. So today, actually, as a consequence of a notification, the thresholds are 1 crore now. But really, there is a large volume of litigation that is presently faced by the NCLT. And a lot of people see this as a pressure tactic, right? So given that the consequences of insolvency are so drastic, even an operational creditor who has extended goods and services, even if he doesn't see any possibility of recovery, simply goes and files an application. Now, the point I'm trying to make here is that it's become a pressure tactic. The ease with which you can go to the court is much lesser. There is consequently a large volume of cases, right? And the process has become standardized. There are, in fact, just forms that you have to fill out. There's a form 1 in the case of a Section 7 financial credit application. There's a form 5 in the case of a Section 9 application. So it's fairly standardized. And as a consequence of all that, the space in pre-admission has become crowded. I'm not saying that there is no scope. It's just become crowded. And it also means that it's a volume game, right? So what that means is that a lot of parties want to get to the NCLT in the cheapest possible means possible. So and because there are so many lawyers and because the process is so standardized and some of the lawyers are every day in the NCLT, they are offering their services at throwaway prices. Now, the reason I'm highlighting all this to you is that it's difficult to make a niche or a sort of, it's difficult to stand out in a volume game, right? And there are advantages as well. The advantages are that you will be in and out of court almost on a daily basis, and there is no substitute as a litigator, to being in court on a daily basis. So the pre-admission phase has its pros and cons. The pros being that you will be in court. The cons being that it's a highly crowded space and it's easy to get lost in the process. Having said all of that, I truly believe, and this is my personal view, that there is a large scope of post-admission related litigation that is in fact already sort of happening right now as we speak. And there is a large scope of very creative argumentation in the post-admission phase. Let me explain why, right? So I've set out in the slide, if you can see, sort of 4 sections that are extremely important. I don't want to get into what each of those sections are, but the point of these sections. So section 31, for instance, so Ravitej spoke about how the end goal of insolvency is a resolution plan. So section 31 basically says that a resolution plan is binding on all stakeholders. So what this means is that I may be someone who's not even a part of the process. I may just be a creditor or a guarantor. I may not be sitting in the committee of creditors, but because of section 31, it binds me. Any resolution plan approved by the financial creditors sitting on the committee of creditors binds me. And what that means is that more often than not, there are going to be stakeholders who are aggrieved by the process, right? So in a post-admission resolution plan situation, we have seen a number of litigators, a number of lawyers fighting for stakeholders who are aggrieved by the process. Of course, there is a number of decisions that have come and said that, look, Section 31 is very overarching, you can't object to it, but there is still scope. Section 65C and Section 63 basically say that the NCLT has overarching jurisdiction. It excludes the civil courts. Anything to do with the insolvency process, you have to come to the NCLT, which means that any person who has a problem with the process is forced to go to the NCLT, and a person who specializes in appearing before the NCLT is therefore sort of very attractive and is someone that I would want to seek advice from, right? So this is again, I would think, a sort of attractive means by which you can be an insolvency lawyer in a post-admission situation. And lastly, Section 238. Section 238 is one of the most spoken about provisions in the insolvency code. Section 238 has a non-obstante clause. Some of you will know that if you've studied your interpretation of statutes. It basically has an overriding effect, notwithstanding anything contained in any other law for the time being enforced. So what all these sections effectively mean is that an insolvency lawyer in a post-admission situation, if there is a resolution plan that has sort of carved out the rights and liabilities of the stakeholders, he can bulldoze all the other laws. I mean, of course, subject to exceptions, but the limited point I'm trying to make is that there is an overarching effect, and as a consequence of that, an insolvency lawyer has tremendous potential in a post-admission situation. That brings me to avenues. Most of you know, as lawyers, once you get out of law school, once you graduate from law school, really there are 2 buckets. Of course, as litigators and transaction lawyers, but within the litigation space, there are independent lawyers, counsels, and there are law firms. Of course, the compensation is variable for each of these things, and really would depend on sort of the sort of setup that you're in. A lot of independent lawyers also pay significant remuneration, but really depends on the sort of track record that a lawyer has had, and the kind of work he is doing and things like that. But really the point, while I finish this piece on litigation, the point I'm trying to make is that as a litigator, there is no substitute to day in, day out litigation if you really want to learn. And while compensation is an extremely relevant factor, the primary, if you are interested in litigation, your primary goal has to be to ascertain whether there is a day in, day out sort of interaction with the courts. Utkarsh, can you move to the next slide, please? Right, so we spoke about litigation. A lot of you NUJS people may be like, look, I don't want to talk about litigation. Talk to me about the big bucks. Talk to me about transactional lawyers. I can tell you as a matter of personal experience that I started out as a corporate lawyer with Ketan on rotation. So I did corporate for about 6 months. A lot of people really enjoy it, right? A lot of my colleagues, very dear friends of mine, are in corporate law and they love it for whatever those reasons are. What I intend on doing in this slide is to tell you what you can do as a restructuring lawyer, as a restructuring corporate lawyer. So Ravitej spoke about restructuring. So what exactly is restructuring, you may ask? Restructuring really is when I am a debtor, I don't want to take examples, I don't want to take names, but I am a debtor, I have severely defaulted in payments, and I basically go to the bank or the financial creditor and I tell them very plainly that, look, I'm not in a position to pay my debts, I'm not in a position to pay my interest. So please restructure the loan in a manner where you can either waive interest payments, or you can take additional security, or give me more time, right? So that's what I mean by saying those three things under the restructuring tab. The idea is that it gives you more time to sort of pay those debts, and you sort of ward off the sort of drastic consequences that Ravitej spoke of while you commence insolvency, right? So this is what restructuring is, and a lot of banking and finance lawyers in firms, even independent lawyers, basically structure their documentation after negotiating with banks on how to, sort of come up with an optimum solution, in a debt-ridden sort of situation. So that's really what a very simple primer on what restructuring is. The second one is strategic acquisition, right? So this is extremely important. In fact, one of the very recent matters I worked on was for a listed company in Gujarat, um, an asset reconstruction company. I mean, I don't want to trouble you with the details, but really, what ARCs do are that they take on asset-heavy, attractive assets at throwaway prices, right? So what that means is that because you're in a debt sort of situation, and because the promoters are potentially going to be sort of taken out of their control, as a consequence of that, you sort of want to you allow for those assets to be acquired at a very cheap rate, and the IBC process allows for that strategic acquisition avenues. There are specialized firms in Delhi, in Bombay, actually even in Bangalore and Calcutta, um, that deal solely with restructuring. Then there are individual lawyers also who sort of do this, and then there are of course law firms who in banking and finance teams and in the corporate and M&A teams that do both restructuring and strategic acquisitions. Lastly, what are the emerging trends? Look, the code is seeing a phase wise implementation of their provisions. So part one and part two is what Ravitej spoke of, which is really to the commencement of corporate insolvency resolution process, that is against a corporate debtor. Part three of the code deals with individuals, so a personal insolvency. Now this is extremely high stakes, right? Because here you're talking about an individual's reputation and an individual's assets that are on the line simply because he say extended a personal guarantee, right? So the corporate debtor has failed, the resolution process has gone through, the banks have not earned much money, the banks still want money, so they have a guarantee, so they initiate individual insolvency. Tremendous potential in this space. Look, the beauty of taking any new law or specializing in any new law is that on a daily basis the law is evolving, right? So when you get out of law school, you may think that X is the sort of status quo. It's going to change, and while they are trying to standardize, I mean, part two is sort of standardized, which is what I dealt with in the my previous slide. Things like part three of the code is an ever evolving sort of thing, so you want to get in on that because you learn the most while you're actually interacting with the law as it evolves. There is also a career as an insolvency resolution professional. I won't encourage or discourage it. uh, what it I mean, an insolvency resolution professional has a sort of administrative duty, right? Once the insolvency process starts, what the insolvency resolution professional is supposed to do is to assess the claims, convene the meetings of the committee of creditors, see what are the viable resolution plans, look at whether all stakeholders are dealt with. So really, that's another career option. Another thing that's not highlighted here that I want to touch upon is there is an immense potential in the policy and regulatory space. A lot of you may be interested in legislative research and specialized sort of regulations, because the insolvency code has a specialized agency called the IBBI, which is the Insolvency and Bankruptcy Board of India. Uh, there are often sort of research deputations given out for people to sort of enable the thinking of the specialized agency. So there's a tremendous potential even in legislative research. I'd like to end my slide with this quote that really has sort of helped me make my career choices. I don't believe that specialization is a sort of the be all and end all of things. Look, you can be a specialized lawyer, but the problem with being a specialist is that sometimes you may get bored with the monotony. I mean, I'm putting it very simply, but there are lots of specialized lawyers who are doing extremely well in their respective practice areas. I would, as a matter of personal opinion, sort of recommend uh, a diverse sort of practice. So, you need to look at it as a commercial lawyer, and you need to look at it as insolvency just being one among the many options of debt enforcement. So, Tim Ferriss has said that Jack of all trades, master of none is an artificial pairing, uh, and it's possibly even a false dichotomy. Uh, and really, the most important thing is that it's entirely possible to be a jack of all trades and a master of many. And don't confuse perfection with mastery. You can be a extremely good practitioner, but you need not be perfect at it, but you can still be extremely effective. I'd like to leave it with that, and I'll hand it over to Utkarsh to take it from here. Thanks, guys.
Can I just
Yeah, of course, of course.
Yeah.
Sorry. Please, Ravitej, please come in.
No. Just to sort of take it from what you just said, jack of all trades, master of many things. You've spoken about litigators, you've spoken about transactional lawyers. Another thing which is just interesting, which I've seen, noticing more at a post approval of the plan stage, is where for the same scope of work, you have both transactional lawyers and litigating lawyers working together.
Yeah,
And that's
right.
something that both, you know what I'm talking about as well, right? And that's something which is very interesting, where a lot of times you feel like as a litigating lawyer, your role comes in when there's a dispute, or as a transactional lawyer, you feel your role ends the moment the dispute commences and the litigation team takes over. That's
right.
something that I've seen change with insolvency more than anything else, because
Yeah.
for just a simple example, say your plan is approved, there's a challenge to the plan post approval, or post approval of a plan, you're trying to challenge it on force majeure grounds, saying the plan is not implementable anymore. You
Right.
need to work very closely with the transactional lawyer in that
Yeah.
case as well.
Yeah.
And that's something which has been extremely interesting, because I did transactional law for 2 years before I jumped to lit, and you realize that your roles changed massively, and sometimes there's so much you get to learn when you sort of see things from the other side. And in a pure civil litigation stage, you may not really experience that, but as an insolvency practitioner, that's something that I found very interesting and very enriching, to that sense that to see things from a transactional perspective and vice versa. So I think that's been one big gain as a lawyer.
Yes, I agree with you. I agree with you.
So that's it. Yeah, Utkarsh, over to you.
Yeah, thank you, Ravitej and Mr. Joseph, for this very interesting session. Now, as somebody who's an academic and but interested in financial laws, I could actually appreciate the different kinds of contours that you mentioned, both in the act itself as well as the difference in the approach that may be needed from a practitioner's perspective. If So I'm sure the students and others who have actually participated have also quite a valuable take back from there. Now, with regard to our next session, with this we'll go into the next session, which is essentially a little bit of Q&A session, wherein we will be trying to understand the different and aspects of the career path lies in the restructuring and insolvency practice area. I know that both of you have actually referred in your presentations and discussions so far about it. So some of the common questions that a lot of students and seem to be asking these days is that what exactly if you consider that being an insolvency lawyer requires some specific skill sets, what would you say those skill sets are? Anything above and beyond a litigator? If you want to be an insolvency, if you want to be a litigating IBC practitioner, then what exactly do you need?
So I'll say something, and I don't think Shavik you'll appreciate it too much when I say this, but you acquire most skills on the job. At least I wasn't like the most academic person in college, right? And I don't feel like that most of us doing this today have come in with a lot of acquired knowledge in college and therefore are easier, fit into this a lot better. Of course, it helps to understand how the code functions. It helps to understand general banking terms and basic taxation terms. But a lot of it is stuff that you can pick up on the job. I think with not just insolvency, with everything, I just feel that you can, every skill can be acquired. It's not like sport where you need to come in with predisposed talent. No, I don't feel that way. It obviously helps. You're ahead by a few months if you do understand how the code functions and you basically understand how debt, basic taxation concepts like PAT, EBITDA, things like that probably work. But I don't think there's something that you require to know before you come in. But again, that's maybe me saying that. That's just my personal view, because that's how it's been for me. I learned most of what the code never existed when I was in college, right? The code came in 3 or 4 years back when I was already doing litigation. So for me, I don't see that too much as of a handicap. Uh, but yes, of course, like while you're doing it, you're expected to learn, you're expected to read, you're expected to follow market trends. So that's something which is very important. So if today, generally as a law student, or in your fourth and fifth year, if you can just follow the market, read the Economic Times, just that itself to me is great. Like, because you're understanding the market, you're predisposed to understanding how things work. The law and the practice you can learn as you go. But to basically understand how the market functions and to have a pulse for it, that's important. It comes to your interest. I think that's, if you develop that interest, I think that's you're one step ahead of everyone else. Zach, your thoughts on that? You're on mute. You're on mute.
Zach, I guess you're on mute.
Zach, you're on mute.
No, I agree with what you're saying. I mean, what skills do you need? Look, you have to have an interest in the practice area. There is no substitute to being interested, and you need to keep yourself well read. I mean, see, it's difficult to tell you all as students that you must read judgments every day and stuff, because there's a significant academic backlog. Or a significant academic pressure that you have, but look, you have to develop an interest, and at least I can say that, like Ravitej said, the interest in this practice area came for me only after I got work. So in your case, I guess it has to do with getting in on internships, and in those internships asking for, trying to identify the kind of people who are doing that kind of work, and then sort of doing assignments while at that internship. I think that's the only sort of additional input I'd like to put in here.
Great, thanks, guys. So I guess Shovik has dropped out, so I'll take it forward. Now, the second question which we received from students are now practicing here as a IBC lawyer. Except IBC itself, what other legislations are important to understand?
Right. So, look, there are 2 or 3 things I would imagine. The first is the Contract Act, right? So there is no substitute to the Contract Act. And by Contract Act, I mean not just provisions relating to guarantee, indemnity, and the like. I'm talking about from the basics: what makes a valid contract, what is valid consideration, what is a void contract. At the end of the day, what we're seeking to enforce, even in the insolvency process, is a contract. So having your first principles solid on the Contract Act is an absolute non-negotiable. The second I would think is the Companies Act, really, because the NCLT is and in fact not all the provisions of the Companies Act, as much as just the provisions relating to the constitution of the NCLT itself. So yeah, the Companies Act, the Contract Act, and of course, look, you have to have an understanding of how commercial laws work, and that's a wide gamut of laws. I mean, that's you need to understand both the procedural aspects of it and the substantive aspects of it. But if I was to, in this short sort of duration of time, pinpoint two, I would say the Contract Act and the Companies Act. Ravitej?
Okay.
No, agreed.
Okay. So that again, from the perspective of a junior lawyer, maybe a lawyer possibly say 2-3 year PQE down the line, yeah, or a fresher, right? What are the major do's and don'ts as a young lawyer practicing in the IBC practice?
Ravitej knows all the do's and don'ts.
I know the don'ts. That's why I know the do's.
From the perspective of a firm as a lawyer itself.
Yeah. Of course.
I think when a junior lawyer comes in, the first thing I look for in that person, and to me, that's the most important skill to have, is application of mind. You may not know the law inside out. You may not know the happenings around the world inside out, but you need to apply your mind. That's the first thing. Learn to question things. Don't accept things at their face value. Learn to question things. I think that's the first thing. When you're curious, that's your first thing, because you're curious to learn. You're curious to question what's being asked. You don't accept everything at face value. You apply your own mind. That is the most important skill to have first. Second is to draft. There is a slight difference between moot court drafting and actual pleading drafting. The idea is to say the most in the least amount of words. Short sentences, good English. That to me is extremely, extremely important from a junior lawyer. A short, like to the point draft, short sentences, good English. That is a must. 3, like Zach just said, the basics of Contract Act are Contract Act, Specific Relief Act, basics of the Limitation Act, to me are extremely, extremely fundamental to your growth as a law firm lawyer. Then obviously, depending on your practice area, how much you need to go into Companies Act, how much you need to go into, FEMA 20, things like that, the Arbitration Act, that all depends again from practice to practice. That's not fundamental. To me, fundamental is Contract Act, Specific Relief Act, certain parts of the Arbitration Act, and your parts of the Companies Act, etc. That is a good starting point. So, to sum it up, application of mind, curiosity, simple, basic, good drafting, and your basic fundamental laws. That's what is important, not just as an insolvency lawyer. I think irrespective. As a lawyer joining a law firm, I think these skills are extremely important.
Shobik will take it forward. He's back.
Yeah, Utkarsh, okay, thank you. Ravitej and Mr. Joseph, one question we have actually received from the students is essentially that before a client actually thinks of approaching a lawyer in insolvency matter, is there any prerequisite or say checklist or anything that the client should actually keep in mind? Which is somewhat very interesting question, a bit puzzling for non-practitioners, I'm sure.
Look, you need to know your law inside out. You need to know what constitutes a debt, what constitutes a default, whether there's an admission of default. But look, really, in terms of a checklist, I've said this before, I think even Ravitej mentioned it. Most of these processes are standardized. So, for in a Section 7 application, for instance, there's a Form 1, and the Form 1 forms a part of the rules. And those rules have a very clear checklist of all the documents that are required for the initiation of insolvency in respect of a financial debt. Similarly, in the case of a Form 5, there's a very clear checklist. One of the things that the insolvency law has done is that it's brought in a lot of clarity in the regulatory process, and there's very reactive sort of legislation. So a law comes into force. In practice, it is seen as not working. Stakeholders raise issues, and almost, in a matter of months, there are sort of streamlining processes. In fact, even there's a timeline of how, Ravitej mentioned the 330 days. There's a model timeline that the CIRP regulations have. So don't bother before the client comes, the one thing that you must do is to read your law. So you need to know your IBC, you need to know your regulations, you need to know your rules. Once you pass through this, then you're in a good enough place to be able to advise your client, in my view. There's also a lot of questions on the chat box. I think we should start taking some of these questions.
Yeah. We are going to one after another. Now, there is another question that I have got here, that in your opinion, what exactly is the difference in the practicing in the insolvency sector as a lawyer who is working with the litigation team of a law firm, or say a junior under a counsel directly? And the questionnaire has sought both your recommendation as well as feedback on this.
Ravitej.
So there is a difference. There is a clear difference between what a law firm lawyer does and what a counsel does. So at least, I think again there's a difference between how things in Delhi work, how things in Calcutta works, and how things in Bombay works. But broadly speaking, the transactional aspect, the strategic aspect, and the documentation aspect are things that law firm lawyers do. At least in Bombay, the way I look at it is you get to a counsel when things go into a dispute stage or when things are in court. So you've done the drafting, you've done the strategy, you've put the documents together, you've sort of done the groundwork. What your senior counsel or counsel does in court is pretty much plead that for you. So now, as a counsel, perhaps you may not be that involved in strategy at the initial stage and in the drafting and filing of things. But as a law firm lawyer, you get to do both. A lot of times, obviously, it's client driven, it's stakes driven, whether we argue matters ourselves or we get counsel to argue matters. So there's no one set answer for it, or a recommendation that, I think you should join a law firm, or I think you should do a counsel. That depends on what you want to do. That depends on your broader plan, your mid-level, your mid-term plan and things like that. So there's no one answer to that. But yeah, broadly speaking, that's the difference between what you would do and what a counsel would do.
Right. One student has actually asked a very interesting question. So she says that about having multiple specializations as a possible hedge against different kinds of fluctuations in the market. But she's a bit confused about whether that won't actually make it more difficult to be known for practice areas that way. So obviously she's thinking of long term, but that question is still a valid one, I guess.
So I'll take this one. So excellent question. I think what you must understand is that don't go. I mean, or this is something that my seniors have told me. Don't chase success, right? Just work hard and work develop all-round skills to be an all-round lawyer. The idea is that you don't when a client comes to you, the client doesn't come to you because he wants there's no one answer to that question. There's an altogether sort of global perspective that you often need to give the clients, right? And while specialization helps you in really going in depth, being a general specialist allows you to give a lot more perspective to problem solving. Look, at the end of the day, fundamentally we are problem solvers, right? And it's the same way that how Ravitej spoke of how there's a interweaving of corporate lawyers and litigation lawyers. Why is it that you think that is happening? That's because each complex problems like insolvency and restructuring require a multitude of perspectives. And being a specialist means that beyond the point, you're not going to be very helpful. I mean, you will give your technical gyan, you will advise your client to that extent, but then the client wants to know a little more. So that's why often, there are lots of corporate lawyers, lots of banking and finance lawyers. Ever since the insolvency code came into force, they've started honing their skills in litigation. I mean, they're coming to the NCLT as much as we are. They're writing articles as much as we are. The idea is that it's simply because you can't advise a client if you have a very sort of streamlined approach. You need to have a broad sort of perspective. So I would still believe that you will only be better known if you have a broader and a more wiser counsel that you can sort of give your client. Ravitej, anything that you want to add?
Just quickly to add to that, and not just within one practice area, even broader. Like for both Zach and me, we do equally, if not more, or equal amount of arbitrations as well, and civil litigation, right? Because of that, you get a lot of insight into litigation strategy, which say a purely transaction restructuring lawyer may not
Will
have
not have.
approaching the NCLT. And I've
Yeah.
seen that time and again. Sometimes they may be more theoretical. We could sometimes be more practical because of experience we've derived from other practice areas. The world is obviously somewhere moving towards specialization, and that's great. But I just feel that we today still are in a point in a market, in a country where while it's good to specialize, it helps to multi-specialize to that sense.
Right.
Yeah, Shravik, I'll just quickly take one question, which it comes from Jan, and he's specifically addressed it to me, and it's a very valid question. I've had people ask me that a lot of times. So I did M&A private equity for 2 years. The reason I moved to litigation is not because I felt now that's the natural next progression. I did it because I felt I was really bad at what I was doing, or I was not good at it, or I didn't enjoy it. It was a mix of all these three. And I just felt I was not adding value anywhere. And that the reason I moved to lit was because I spent 5 years in law school and 2 years on a job. I don't want to waste 7 years of my legal background to just immediately move to another thing. So why not? Let's try litigation. It happened to work. Now, do I today see the benefit I had from that? Absolutely. My understanding of an agreement and of transaction is slightly better. Which is why Khaitan used to have a rotation policy, which I believe now they don't anymore. I feel that really benefits people, a rotation policy or even if you do like 2 internships in a corp firm and then come to lit, your understanding of a transaction, of you looking at a contract, is different because you're looking at a contract from a pre-negotiation stage. Which is why Zach, who spent time with the corp team and the competition team in his rotation, will have that perspective. So I think never be one-dimensional when you come in.
Yeah.
It helps to have had a wide range of internships, if not, time at a practice.
Right. Right. One interesting question that the student has asked is that, is it a viable option to start a practice in IBC in Tier 2 cities? Or should fresh lawyers or law grads have to move to Tier 1 cities for this kind of thing?
I'll take that. Mrityunjay, hi Mrityunjay. Look,
Hello, sir.
look, I'll tell you what. There are lots of people who have started their IBC practice in Bombay and in Delhi and have moved to Tier 2 cities like Jaipur, like Indore. All of these are, they make a lot of sense because each of these places have an NCLT bench, right? So when you have an NCLT bench in each of those, so even Cochin, for instance, is one place. I don't want to call it Tier 2 because I'm from there. But look, Tier 2, Tier 1 is not important. What is important is that as an IBC practitioner, your bread and butter will be, there's always going to be debt and default in any city wherever there is business, and what you need to look at is whether there is an NCLT bench. So if there is an NCLT bench, I would think IBC specialization is extremely valuable because what that does is it gives you, there's one specialized forum that you can sort of access. Otherwise, having said that, I would imagine that it's only really in the nature of litigation that a person would have involvement in those cities. It would be difficult for a corporate lawyer to operate in those cities because a lot of the corporate lawyers sort of operate out of the Tier 1 cities, so to speak.
Thank you, sir. Thank you.
We will take a small question, which is a slightly on a technical aspect, I guess. So Subhash asked that whereas the recent suspension of the IBC that has been considered as a respite for firms which were on the teetering on the edge of insolvency, a lot of people are apparently of the opinion that it can actually promote risky behavior by the upper management instead of aiding all the stakeholders. And he has requested your thoughts on this.
So I'll just take it. Zach, you can chip in at the end if you have something. So one thing, there's a huge misconception on the suspension of the code. The code is not suspended. Okay, the code is there. It's very much there. What they've done is that at least for this COVID period, for a debt related to the COVID period, where there's a default that's happening in this interim, for those you cannot initiate proceedings, right? Now this is say 6 months. Let's assume this is for 6 months and it's not extended further. Your reckless behavior, okay, let's talk about a possibility of risky or reckless behavior by management. But where's the end game, right? Because at the end of 6 months, you're back to a normal track. You will have debts due then, right? Moving forward. And then for those debts, you always have the code open for you. And for debts that predate this COVID period, it's fully open for you to file. For example, I'm right now in the process of filing an insolvency application for a debt which became due last December, right? Because that doesn't come into the COVID scenario. Today, you're talking about debts which, for example, if there are amounts due in April, May, June, and you default on those, yes, you can't initiate insolvency. But 6 months down the line and right after, you will be back on that, right? So it's not like you can take on risks today or go on expansion knowing that you will know your defaults don't count, but your defaults will catch up with you in a few months' time, right?
I think it mostly to do with the peculiar drafting of the notification, which had actually led to the suspension.
The proviso gives some amount of confusion, but I think if you look at the preamble to the amendment, it's fairly clear what they're hinting at.
Right. It's one other question is essentially Alok has sought to. He says that at the risk of sounding technical, could you elaborate on section 238 of the code and how exactly the repugnancy is ascertained and so on and so forth. Now, I think that's a very big question and it can't really be answered in its entirety, but if you can give some pointers to it.
Right. Yeah. So, look, section 238 was actually one of the first few sections tested under the insolvency code in the ICICI Bank versus Innovative Industries judgment of the Supreme Court. Really what, I mean, it's very overarching in its scope. It says notwithstanding, the provisions of this act shall have effect notwithstanding anything contrary contained in any other law for the time being in force. What this automatically means is that any previous legislation. So in the innovative case, it had to do with the Maharashtra Relief Enterprise Undertaking Act, if I'm not wrong, MREU Act, which sort of had a very different mechanism for particular entities to be resolved. So what the Supreme Court held in that case is that, look, this is a subsequent section 238 is a form of in the IBC. It's a subsequent legislation. 238 has an overarching power, but it also held that there is no direct contradiction. So, I mean, in the short span of section 238 itself can be part of one webinar. But if I am to sort of cull it down to 2 or 3 very fundamental principles, the first principle is that you need to see if there is a direct contradiction. Is there a direct sort of clash of the laws? Only if there is a direct clash of the laws will 238 be triggered. And the judgments of the Supreme Court are very clear on non-obstante clauses generally, that because of the drastic effects of such a clause, you need to show that there is a complete direct contradiction. I mean, it's not just a slight sort of contradiction in objectives. So that's number one. And number two that you need to see is, a subsequent legislation. So you need to see if IBC, if there are legislations after the IBC that deal with the same sort of subject matter, then it's 238 is probably not going to be attracted in that case. But yes, you need to sort of restrictively apply 238, and you need to show a direct sort of contradiction in the legislation.
Right. Can you tell us how exactly cross-border insolvency has actually been affected after the code has come into picture? That's something one of the students is asking.
Sorry, I missed that, Shravik. Can you just say that again?
So basically, a student wants to know what exactly has been the impact of the code on cross-border insolvency matters.
That's intense, but
yeah.
So the cross-border insolvency matter that I have seen is only the Jet Airways one, where basically what happened really is there was for an aircraft parked at Schiphol Airport, they had a Dutch administrator who went and took control of that. And then when it came to India, the NCLT, or it went up to NCLAT, I'm not sure, didn't really come down and say that there is committee or that India should sort of combine proceedings. What they said is you reach out to the administrator and come up with something, sort of find a way to work together on it. So it wasn't an order on them. So I don't think cross-border insolvency still is sort of.
I think a suggestion to cooperate.
It was a suggestion to cooperate with that, because in that sense, the whole thing hasn't really come into force as such. We haven't seen any cross-border insolvency. The only thing I know of is just Jet Airways.
Yeah, because
no, in fact, it's not been brought into force.
Yeah,
it's still in the legislative stage. There are still consultations happening.
Yeah.
Really, the idea of cross-border insolvency on a very fundamental level is to see when you have companies in insolvency in another jurisdiction, what are the effects of that in the subsidiaries in this jurisdiction, and how you can sort of coalesce and sort of coordinate the entire process. Jet Airways was one such example, but nothing has been brought into force as of yet.
In fact, the reverse is also happening, wherein Indian entities, subsidiaries in Indonesia and Brazil, are sort of also in. So the Indian entity is in insolvency, but it has assets abroad. How do we deal with that? So all of that is still at a nascent state. So cross-border insolvency per se hasn't come in. No, but the closest I've seen, like I said, is just Jet Airways and that aircraft in.
Yeah, I think actually the law school framework has something to do with this people's wide range of interest about cross-border insolvency. And I think the moods also have something to do with it, because I've been seeing this for the past decade and a half, that people are talking so much about cross-border insolvencies, but the actual groundwork development which has happened in this country. At least
that's how it is with everything. Arbitration also is international arbitration which interests people, and it's always cross-border. Everyone wants everything international.
Just one thing. See, look, I mean, one takeaway from all of this is it's important in the context of this conversation that you identify newer areas of law, right? So cross-border insolvency, while we are all saying that it's not in force, it's a very good sign that you're interested in it. It only means that not many people are talking about it. That means that there are greater chances of specialization. So yes, I mean, nothing stops you from sort of specializing in it and writing papers about it, and sort of leading the thought process behind it.
Right. One last question before we end our session today. I think we have addressed most of the important ones. And okay, I think that would be all. Big thanks to both Ravitej and Mr. Joseph for this wonderful session that I'm sure has helped a lot of students and get a lot of clarifications about both IBC in general as well as insolvency practice itself. If I would now ask Utkarsh to just wrap the session up if he has any words for us.
Thanks a lot, guys. Thanks a lot, Ravitej. Thanks a lot, Zach and Shovik, for sparing time and helping our students out. Thank you all the attendees to join today. Yeah, thanks everyone. See you next time for the next webinar. See you guys. Bye.
Thanks, Utkarsh. Thanks, Shovik.
Thank you.
Thanks, Zach. Thanks, everyone. Bye.